Good morning, everyone. My name is Kabelo Letebele, Senior Manager for Communication. Apologies, we were just having a bit of a challenge on our end with regards to the speaker. However, the Education Department have just indicated that Mr. Hussein will join us around about 10:15. So we will start in about 5 minutes at 10:15. Apologies for the inconvenience. Please, let's just hang in there until 10:15. Apologies. Thanks.
Um, Cabello,
Good
Cabello.
morning, sir.
Hi, Cabello.
Good morning.
All right.
W-
Um,
Welcome. Okay. Should we get the process going? Are you ready? I had indicated to start at 10:15.
okay. All
What
right.
what was okay.
10:15. Give people time to come. Uh,
Okay.
the time suits me better now,
Okay.
um, so I don't have to rush through this thing. Um,
Okay.
I see we've got more people than I anticipated. Uh,
Yes.
okay. Um, so we'll start in what, 4 minutes
In
time.
4 minutes, yes, sir. And just to let you know, and the candidates, because we are already live, we will be recording the session.
Yes.
And then after the session is recorded, that my team, the comms team, will put it on our YouTube channel. So this is just to make provision for those who might have missed the session or joined late or any other issue. But we will start in 4 minutes, sir, and everyone on the call.
Okay.
Okay.
Thank you.
Thank you. Good morning, everyone. My name is Kabelo Litebele, Senior Manager for Communication within the Legal Practice Council. Apologies for the slight delay in the starting time. There were a bit of cross lines regarding the starting time, but um, welcome. Thank you for joining us. This is the Advocates Admission Examinations Preparatory Session. The session is being recorded, and the session will be made available um, to all the candidates or everyone who's registered to write the exams via our YouTube channel. It should be uploaded by tomorrow. So if you are not following the LPC YouTube channel, please do so. Please subscribe to it. We also encourage you to follow our other channels on Facebook and on X. And if there are any pressing questions that are not answered in this session or that come after the session, you are welcome to drop us a line on, at the email info@lpc.org.za. Without wasting time, I'd now like to hand over to Advocate Ismail Hussein SC. Advocate, thank you so much for always being willing to help and give guidance for the exams. We really appreciate your time. Over to you, sir.
All right, thank you, and welcome to all the pupils and prospective examination writers. Um, this is a very exciting time because you're on the cusp of qualifying as advocates. It's a fantastic profession, and I basically want to say something about what to expect. Um, I'm going to take, first of all, I'm going to give you the legislative background to this. You know, in the past, we did before the Legal Practice Act came in 2018. The training of candidate attorneys and pupils was run on a fairly loose basis, depending on where you were in the country, which bar, and so on. So there was no consistency. Also, remember, back then, prior to 2018, there was no qualifying exams for advocates. You could admit yourself as an advocate without writing a qualifying exam. It's only the General Council of the Bar and their affiliates that required an, an assessment of one's competence before being admitted. But the admission was not to the bar itself. It was admission to a a a a bar which was affiliated to the General Council of the Bar, such as the Johannesburg Society of Advocates, the Durban Society of Advocates, and so forth. Since then, there have been a number of bars that are operating around the country. But 2018 brought about a big shift. We stopped this idea of people registering as advocates and then being able to practice. That had some unfortunate consequences, as you might know. So in the interest of the public, and also this was discussed at the National Forum, which of course produced the Legal Practice Act. And it was decided that advocates must write competence exams as well, which is what this is. Now, going back to 2019, I was asked by the Legal Practice Council to do a survey and to consult the profession, that's the advocates to start off with, and to prepare a syllabus that will be applicable throughout the country irrespective of which bar you are going to practice at. It could be the Johannesburg Society of Advocates, or it could be the African Bar Association, and it could be the National Bar Association, and so on. Um, what we want is for everyone uh, to have the benefit of two things: a syllabus that will guide your training, and to support that syllabus, you will have a reading list. Now, all the bars that I consulted were very clear that they want such a syllabus and a reading list. And such a syllabus was prepared. It was, as well as the reading list, it was circulated to all the bars, and ultimately it was improved. It was actually um, approved by the Legal Practice Council. Now, the training that is required in terms of the Legal Practice Act is vocational training, not academic training. You did that in LLB. This is supposed to be vocational training. So what we are going to make an assessment of in this exam are your vocational skills. So what's going to happen is that you will not be asked academic style examination questions, like write a short note for 15 marks on some aspect of the law. That's not going to happen. The practice of law, be it an advocate or an attorney, involves you as a practitioner to apply your mind to everything. Law involves constantly thinking about what you do. Now, you may have come across already in your during pupillage, some of you may have been practicing as attorneys, this thing called a precedent. Now, this is a real problem because once you start using precedents, you stop thinking. So what we want to do in this exam is to achieve the purpose of the Legal Practice Act, and that is to test or make an assessment of your vocational skills. Are you competent enough to go out into the public and represent people in a courtroom? Do you know how to do that? You've got an LLB where you learned the law and where to find the law. Now you have to show your competence in applying the law. That's what it's about. Applying the law to the facts of your case is basically what advocates do. Once you've done that, you then start drafting papers. You then end up presenting your client's case in court, all of which require skills that you did not get at university and skills that you will keep developing and never stop developing as you go through your career. So what I'm going to do is today is give you some guidance on how to handle an examination which is totally different from what you did at university. This is about assessing your vocational skills. What does that mean? It means we want to see that you have the necessary competence to practice as an advocate. That does not mean that we expect you to be perfect. That's not the case. What pupillage provides you with the basic skills. From there, you are assessed. You are then allowed to practice as an advocate. When you go into practice as an advocate, you never stop learning and developing your skills. It is a fantastic profession. It is highly rewarding, provided you practice it correctly. The start is now. If you can answer these questions in this examination, you can be confident that you will make a success of your careers. And that's the very nature of this exam. This exam is going to test your ability to solve problems, to understand a legal problem, to be able to work out what the answer is, and then to express yourself accurately on paper. So it is not a pushover. Don't get me wrong, it's not a pushover. You are going to have to work. Now, one of the things that you have in your favor that people like me never had when we did pupillage, that was you have a syllabus, so you know which vocational skills that you will be required to have, which is consistent with regulation, where someone is not muted. Always one of those. Oh. Who's making the mistakes?
I think it's Charity Lala.
Could you mute her, please? Oh, God. Someone forgot to show her how to do this as part of her vocational skills. Anyway, all right. Looks like she stopped now. Okay. The exams, as I told you, test your vocational skills. So what you will have is a syllabus. Everyone covers the same topics. The Act and the regulations, in Regulation 610, I think it is, provides for modules of coursework. These are prescribed coursework for advocates. The syllabus is based on that, and sitting on top of all of that is what we call the norms and standards. You would have read the norms and standards. I wrote those as well. And those norms and standards are a requirement of the Legal Practice Act. So the vocational training of both attorneys and advocates must follow or apply those norms and standards. This is done in the interest of providing a consistent, good quality of training and assessment across the board. It doesn't matter whether you're in Cape Town or you're in Polokwane, it's going to be the same. Okay. There was a time when whether you succeeded or not, depending on where in the country you were, that doesn't, we don't have that problem anymore. Then the syllabus is supported by a reading list. And that's important. Not only are you told these are the prescribed areas of practice that you are going to concentrate on, it then supports it by saying, here's the reading list. Now, when you're an advocate, your job as an advocate is to analyze the facts of a legal problem, find the appropriate, contextualize the problem, find the legal materials, the references. As an advocate, the most important authority you can use in court are primary authorities, and that's two sources: statute and case law. So what you will see in the reading list is case law. There's recommended textbooks there that you are expected to read, and those textbooks help you with your skills. But the most important thing for an advocate is the case law. In our courts, there's only one law that is binding on a judge, and that is statutes and case law. Textbooks, journals, all of those other authorities that we call secondary authorities do not bind a judge. Now, advocates in particular use case law. That's the foundation of everything that you do. Now, what you will see in this reading list is case law. If you read through the cases that we gave you, if you followed the coursework in the syllabus, you will be able to manage this exam, simply because if it's not in the syllabus and it's not in the table of cases or the list of authorities that we gave you, it will not be in the exam. It's simple. Now, what can happen is that there's a new case which sets a new precedent, which is important for you. You might get asked a question about that, but it's not in the reading list. So to be fair to you, when something like that happens, and it doesn't often happen because we update the reading list every year, when that happens, we will provide you with the judgment and we will give you time to read the judgment. So nobody is going to get ambushed with something that they didn't see before. That's the big advantage, okay? So if during pupillage you diligently read the cases, you are going to pass. It's as simple as that. But if you ignored it all and didn't bother with it, well, forget it. Your chances are not very, very good, because this is a vocational, this is testing your vocational skills. We're testing to see if you understood the legal principles as they are stated in the main authorities, namely the judgments. The most important source of authority for an advocate is the most recent decision of the highest court. That's it. And we tried our very best to provide you with the best binding judgments in your reading list, okay? So the Legal Practice Act, Section 26, requires pupils to undergo practical vocational training. It's not the LLB. 26D then requires, post the training, to pass a competency-based examination. That's the key. Two key words: vocational training and competency-based assessments. That's what you're going to get. The purpose of the assessment is for the Legal Practice Council to establish that the pupil has attained an adequate level of competence to be enrolled as a practitioner. We don't want you to be of a silk quality when you write this exam. That will happen 20 years from now. What we want you to have is adequate competence to go and serve the public without being a danger to the public. If you read through the syllabus, read the reading list, you will have that level of competence. There are other practical competencies that we are not going to be assessing in this exam, such as your ability on your feet in court. We can't test your trial advocacy skills in an examination like this. We expect that you would have been on a trial advocacy course. We will be testing 5 different areas of competencies. Now, the Regulation 7, sorry, it's not 6, 6 is, Regulation 7 sets out the structured coursework. Regulation 7.9 is for advocates. The syllabus that you have is based on 7.9. And if you look at the structure of the examinations, and I'll take you through that, it is based on Regulation 7.9. The regulations require that the coursework must be supported by a set of norms and standards, which we have done. If you go and read the norms and standards, and then read the coursework, you will see a reflection of the norms and standards in that coursework. So, as I told you, the LPC published the curriculum and the reading list. And this sets out the content of the coursework and the prescribed reading lists. As I told you, the prescribed reading list is heavily populated with case law, because case law is the advocate's source of law, not textbooks and so on. You can go to a textbook for general principles. They're great for guiding you. But the most useful thing about textbooks is that they refer you to the cases, you see. Now, what we've done for you as pupils, we've given you the cases. You don't have to go and find it for yourself. As we had to do, we didn't have a reading list, okay? So the reading list plays a crucial role in the training of advocates. You must constantly be researching, and the most important law is primary sources. Case law, we're a common law country. What that means is the law is what the courts say is the law. So primary sources includes case law, judgments, and statutes. Knowing how to find and read and apply case law is fundamental. Now, that's what we try to achieve with the syllabus and the reading list. You are not supposed to read any of those cases passively. In other words, graze through it, copy and paste it somewhere. That's not researching, okay? You must understand the underlying principles. What is the reasoning behind the rule? Every rule of law has a set of reasoning that makes it a rule, okay? If you read a judgment, what we did in the reading list, to make it easier for you, we did not expect you to read the whole judgment. You will see that we refer you to specific paragraphs of the judgment. That's what you need to read, and that's all you need to understand, and that will be good enough to get you through this exam. Now, the curriculum and the reading lists were carefully put together in order to set a standard according to the norms and standards so that you can obtain the required vocational skills. And the examinations are there to make an assessment of those skills. And I'm repeating this, if it is not in the syllabus, if it ain't in the reading list, it ain't in the exams. Simple. It's not going to be assessed. This assists pupils. It provides direction and guides the pupils. You don't have to speculate nervously about what could possibly come out in the exams and so on. Just let me get one thing straight, okay? You might have heard from the candidate attorneys. Some of you may have been attorneys. I was an attorney before I went to the bar. The attorneys' exams until this year, 2025, if you went through all the past papers and worked out the answers, you passed. You needed absolutely no vocational skills because the same questions kept getting repeated. Well, let me warn you, it is a good idea to look at past papers for this exam. Okay, the LPC only took over this in 2018. So I think we did about about 8 or 9 national exams already with this system. But anyway, doesn't matter. The papers are available. Good idea to go through them. You will not see the same questions coming over and over again, like the attorney's admission exams. Okay. From next year, the attorneys will have also a syllabus and a reading list, and their examinations are going to be like yours. It's going to be testing your vocational skills. Okay. Now, let's go to the exams themselves. There are 5 papers. Paper 1 is motion court. That's well, papers 1, 2, 3, and 4 are 1-hour papers. Paper 5, legal writing and drafting, is a 5-hour paper. It's open book. And what we've done is, where we gave you a question that is based on a particular judgment. Now, in the past, pupils used to write in a library, and we used to allow them to write in chambers, like you see behind me. All the authorities were there. We can't do that anymore. And nor can we give you electronic access in the exams themselves for security reasons. So what we will do, if there is an important judgment, we will give you a copy of it. It'll be attached to your question paper, and we will give you some extra time to read it where it's necessary. So the exams are absolutely fair to everyone. There are no traps. If you diligently work through your syllabus and reading list, and if you went and complied with the requirements in Regulation 7, you'll enjoy this exam. You know, one of the complaints that we got from the attorneys is that, well, they have to go through past papers and speculate and so on, and it's very unfair. They would like to have exams like the pupils get, because they've looked at at the papers you are writing, and they find it interesting and challenging. And we often get comments from pupils that they enjoyed the paper. It was challenging. It had an answer. They were able to handle it, and it was not a problem. And I can't see that. I can't see anything else happening to you. What I'm saying to you is that it's not an impossible exam. We no longer use, well, I shouldn't say no longer, these examinations, contrary to what many people might think, is not there to act as a barrier to entry. It certainly is not, okay? I'm involved in setting the syllabuses and the reading lists. I also moderate the exams. I can assure you that there will be no traps. There will be no questions that you can't figure out. The examination is there to merely do what the Act says: test your competence to practice as an advocate. Don't believe anyone that tells you that the Legal Practice Council uses it as a barrier to entry. It's not true. You must have heard those rumors by now. It's rubbish, okay? So, paper 1 is motion court. and IT. Paper 2, trial court proceedings and ADR. Paper 3 is criminal procedure. Paper 4 is ethics and constitutional and customary law. And your paper 5 is a 5-hour legal writing paper. Okay. Now, the compulsory court work and pupillage is there to provide you with vocational training. Now, this is what we want to assess. Firstly, if it's vocational training, then learning by rote, that is swatting and spewing in an exam like you did at university and like the attorneys are still doing in their exams, serves no vocational purpose. Swatting serves no vocational purpose. And people attend this webinar because they think they can get some tips from me. Okay, now here's your first tip. Every question you get involves your understanding of the law and your ability to solve the problem like an advocate will. If you're one of those people that tried to swat and learn by rote, if you went and swatted model answers of the past papers like the attorneys do, this exam's going to be tough for you. Seriously, because you won't manage. Okay? We want you to learn skills you can apply. That is vocational assessment. We are going to give you questions where we're going to test your application of practical skills. We'll give you a problem. We're basically going to say, right, you've been briefed. What are you going to do? What do you do? Tell us how you're going to deal with this. What will your approach be? Okay, what will your advice be? So the emphasis is on understanding, problem solving, and knowing what to do and how to do. That's the purpose of vocational training, and we will be assessing precisely that. There will be no essay type questions. Absolutely not. Okay. I remember 2 or 3 years ago, in one of the papers for the candidate attorneys, by the way, I have nothing to do with those papers. Okay, I'll have something to do with the papers in 2026. The past, the attorney's exams, which I wrote as well, did not serve the purposes of the Act and the regulations. A question came up in that exam, and it went like this: what is business rescue? For 35 marks. I mean, what kind of question is that? It's nonsense. You're not testing any vocational skills. And those poor candidates failed like flies. Nobody passed that exam. The failure rate was so high that the LPC had to carry out an inquiry into it. That's never going to happen to you, okay? You can expect that there will be questions that require you to apply your knowledge and skills to everyday type problems that come with a brief. There's going to be nothing there that is complex, difficult to understand. You've never come across it before. It will be a concept that is new to you. There'll be principles of law you never came across. None of that's going to happen. You've got the materials already. So what does it take? Thorough preparation. You had a whole year to do that. Critical thinking skills. Now, you see, advocates, in fact, lawyers generally, attorneys as well, everything you do requires thinking skills, okay? You can't be a copy and paste moron all your life. You need to think everything through. This is what pupillage is about. It's what practicing an advocate is about. And you need an effective exam strategy. I'm going to deal with that now. So let's look at some practical suggestions first. For God's sake, you know, you're living in South Africa. We've got transport issues. We have all kinds of problems, from bad weather to some disgruntled people blocking the roads. The drivers went on strike. You know, the problems, what can possibly go wrong is quite endless, okay? So please give yourself enough time to get to the exam venue. Find out where the venue is. Make sure you know how to get there. Make sure you arrange the transport to get there. Leave home early. I'll tell you what the problem is. If you are going to be late, okay, you will not be allowed into the exam room. We've had this problem in the past where pupils showed up 10 minutes late, 15 minutes late, and expected to be allowed in. It's disruptive of those who are there, and the invigilators will not let you in. So make sure you're there on time. I'm mentioning this because we've had the problem. We've got exam writing, exam centers, you've got those venues are accessible. That's why they've been selected. And you are expected to be there on time. Make sure you have all the correct documentation. I'm sure that the LPC would have given you these details. All the documents you need, like your proof of registration as a pupil, your ID, of registration as a pupil, your ID. Yeah. Listen, there's a feedback I'm hearing now. There's a feedback I'm hearing now. Okay. You must have reliable. You must have fields. Reliable fields. Can
Okay.
somebody Cabello?
We're just checking quickly for you, sir. We'll resolve the matter shortly. We're checking who's not muted. Thank you.
Even you are.
Who's not muted.
Even you are. Okay. Make sure you have enough. Make sure you have 2 or 3 pens. Okay, you provide the paper. Paper. So make sure you have these things. Don't get venue and borrowing pens. I don't think invigilator have these materials to supply. So not create panic for yourself. Right, now let's get to the exam papers. Oh, this is impossible, Cabello. Now, we're going to look at exam technique. It's very important, okay? Now, very important. Firstly, I told you, don't make panic for yourself. Get there on time. You must be calm. You must be calm. Have a coffee outside. Chat to your family. If you've done the work, there's a problem here. Nsele, what's the problem?
Yes, good morning, sir. I want to suggest that if somebody can resolve the issue of feedback, because it's reflecting very bad to us and we can't hear you. We hear that you're saying something, but we can't grasp it. So can that please be resolved?
Yeah, no, I can't handle this myself.
So can we just pause maybe for a few minutes? I've asked my team to just check also on my side. It seems that everyone is muted on our side. So perhaps if we can just pause for about 2 minutes, and my IT team also is looking into the matter.
Well, Cabello, you didn't, I think it stopped.
Oh, sure. I'm surprised if, yeah, we were just checking who's not muted. So if everyone can just remain on mute and we can then take questions later. Yeah, all good, sir. Please proceed.
Okay, the echoing has stopped. Okay, all right. Don't get to the venue in a state of panic. You know, you are not supposed to be cramming the night before. It's not that kind of exam, okay? That's what you did at university. I recommend that night before, you shouldn't be worried about the material. You should be relaxed. Watch a movie, read a book, whatever. Get a good night's sleep and get to the venue on time. Please do not create panic for yourselves. You know, many people start panicking because they caused the trouble, okay? So you will be given time to read the question paper and in the beginning. It will tell you on the script itself that it'll give you a description of the paper. It will be paper 1, motion court. It'll tell you the duration is 1 hour, and you'll be given 15 minutes to read the paper. So read through the whole thing end to end, but read actively. Don't skim it. Read it and understand the question. Now, make a note of which questions carry how many marks. Use this to plan your approach to the paper. Because I can tell you, in all 5 papers, the marks are not equally distributed between questions. The number of questions themselves vary from paper to paper. Now, all of these papers, each question carries different marks. There are between 2 and 3 questions that usually carry high marks, but then there are also 2 or 3 questions that carry very low marks, as low as 1 mark each, or 2 marks, or 3 marks, or 5 marks, you see. And then there are others that carry 20 marks or 30 marks. So do not invest a disproportionate amount of time on a question that carries a low mark. Because if you spend a lot of time on a 5-mark question, the next question has 15 marks, and now you're running out of time. Poor time management. So work out, after you've read, which questions can I dispose of quickly and easily? Now, you know those 1-mark and 5-mark questions, I can tell you right now, I can't remember what they are, but you should be able to dispose of them very quickly. So don't linger on them. Rank your questions. Remember to number your questions clearly for the markers. Now, that's very important, okay? Please put down very clearly, indicate which question you are answering. Question 1 or question 5, because it's confusing for the markers if you don't do that, because now they have to try and read the answer and try and work out which question you're dealing with. And that can be very inconvenient. Then begin with the first question according to your ranking. So you made a note of what you're going to answer first, and then answer accordingly. When you start with the first question that you selected, read it again. It is absolutely crucial to understand the question. One of the things you must learn as an advocate is that you are going to spend the rest of your life answering questions, answering legal problems, answering factual problems. How on earth are you going to answer a question if you don't understand it? Now, it is crucial to understand the question. I can tell you that you will find no questions in your papers that's difficult to understand. They are set out clearly. They have only one meaning. There are no questions that you'll find confusing. There are no questions that have more than one answer or meaning to the question. So you should be able to understand it clearly. If you make an error in understanding the question, you are going to be misdirected in your answer. Simple as that, okay? When you get to court one day, the first thing the judge will ask you is, what is the issue before me? What question do you want me to answer? Now, if you got that question wrong, you will not get the answer right, and the judge won't be persuaded by you. It's the same with this exam. And then the next thing is, you've chosen a question, and you've prepared the ranking or the sequence in which you will answer the questions. Please stick to your sequence. That is why you must read carefully and understand the questions from the start, and then rank them and then write them, okay? Write the answers. The one thing you do not do, start with a question you chose and then think, I don't know enough about this. Let me go to the next one. Or let me go to the third one. And you'll be going up and down your list, wasting a lot of time, okay? Just deal with the question you chose, complete it, move on. What you don't do is sit down and chew your nails over a question and allow the time to go ticking by. And then when you get to your fourth question, you've run out of time, okay? Now, can you also, I know this is not easy for everyone. Please write, what's causing that now? It's something Tabiso is doing. Okay. Please write legibly. You know, I'm an examiner. I can tell you one of the hardest thing about being an examiner is to figure out the writing. Now, I moderate these exams. I will not allow anyone to be failed because they wrote badly. It's not a writing test. We're not doing an assessment of your writing skills. We want you to write legibly. It doesn't have to be beautiful, okay? But please don't write like a police officer. Now you can't, you know, it's so difficult. You know, we're working at night. It's tiring. And then you get a script that is difficult to fathom. You know, I've seen examiners go from one examiner to another to say, listen, can you read what this person wrote? Now, examiners, I can tell you, we select them carefully. They are people who are patient and they want to read what you've written. They're not going to penalize you for bad writing. But at the same time, make the effort to write legibly. I don't know, it seems to be a gender thing. The women seem to write really well, beautifully. The men, oh God, police officers. Use numbered paragraphs when you write and write in plain language. If you did writing courses, you will know this from your writing course. It applies to the exams. Use numbered paragraphs and use plain language. You must be relevant. That's crucial. You must answer the question and do no more. That's it, okay? You know, I was reading a biography of Albert Einstein. Some of you may have heard of him. So Einstein was, someone asked, he didn't write the biography himself. There was a biographer who wrote it. And he was reporting that someone asked Albert Einstein, to define what he considers to be a good question. Now think about that. What's a good question? When politicians want to buy time, they'll say to the interviewer, "Oh, that's a very good question. I'm glad you asked it," and then proceed not to answer it. You dare not do that as an advocate. As an advocate, you must understand the question and answer it. Now, guess what Einstein said? It was brilliant. He said, those of you who read my book on drafting or trial advocacy will have read it there. He said, a good question is one that is understood and it has an answer. Think about it. That's brilliant. It must be understood and it has an answer. That's how you write exams. Understand the question and come up with the answer that is expected. Don't be irrelevant. If you have nothing more to say, don't say it. Okay? The length of your answer in this exam, totally irrelevant. We've given maximum marks for someone who wrote 5 lines. Spot on, relevant, to the point, maximum marks. And then someone wrote a whole page and failed. Okay? So length, it's not about length, okay? Spend time reading your answer and correcting the errors instead. Read your answer, okay? If you feel you cannot write anymore, let's say you exhausted your knowledge for a particular question. Please don't sit there and chew your nails and scratch your head and look around. You are wasting time. These are all 1-hour exams. You're not going to get more time, okay? Move on. Now, this is very important. When you answer a question, these questions are testing your ability to understand the problem and answer it. It's an assessment of vocational skills. You will be presented with a set of facts. Now, most of you would have done what we call case studies during your pupillage. You are given a statement of facts and you are told, advise the client, or what would you do? So you are expected to solve the problem and answer the question. Read the facts carefully. If you rush through it, you will be misdirected, okay? And the trick is to read actively. Active reading means you engage with the text. You're not skimming or grazing, as you mostly did at university. Engage with the text. What are these facts? What area of the law is this? What is the problem? Where will I find the answer? Okay. Then only set about answering the question based on your main points. And here's a tip number 2 for you. When you read a question, the answer is in the facts. Seriously, the answer is in the facts. Always think before you write. Now remember, if you swatted something, it's going to be of no use in this exam. Okay? You are supposed to reason it out, and your answer must reflect your reasons. Why is this relevant to the question? If I'm writing something, why is it relevant to the question? How does it assist me to answer the question? Am I answering the substance of the question, or am I padding nonsense around it? Have I made the point? These are the questions that will be going through your mind, okay? Now, I've got a heading on the screen. It says, what about me? Listen, to be an advocate, it's like any other profession. You must take care of yourself. Self-care during exams is as important as studying. You must get enough sleep. You must eat well and eat responsibly. You must keep fit. I'm 70 years old, but I exercise every morning. It keeps me fit. Okay, I'm going to finish with you. I've got a 4-hour lecture this afternoon. I've got the energy to do it because I keep physically fit. And by the way, being an advocate is a physically taxing profession because you're not sitting on your backside all the time. You're walking to court, you're carrying paper, you're carrying files and computers, you're on your feet in court, you're sitting down, you're getting up, you're addressing the judge, you're talking, you're thinking on your feet. It's not an easy job, okay? So keeping fit will also help you to manage stress and anxiety. This is a stressful profession, but there are two things you need to do to manage stress. The one is prepare thoroughly for whatever you do. Number two, keep physically fit. Good mental and physical health will enable you to focus, manage stress, and maintain a calm, reasoned approach to your paper. You need to be very calm. You know, when you read through the question paper, there will be questions there that you think is difficult. For example, you're reading a question which is a set of facts, and you're not really grasping it. So you think, this is a very difficult question. Okay, so you'll deal with that last. But when you go back to it, read it again, read it actively, and then you will see you'll be able to answer it. Break the question up into different parts, and then you will get the answer. And it's always a good thing to believe in yourself. Don't walk into the exam thinking, oh, heavens, I'm not going to make it. Oh, no, I need a drink. No, that doesn't work. Stay positive. Walk into the exam with confidence. Okay? That is how you deal with an exam. Well, good luck to all of you. I'm sure you'll do well. If there are a few relevant questions, I'll take them. The time for giving tips is finished. I've done that. Okay. Cabello, could you manage the questions? Are there any?
I'm going to request that anyone who'd like to ask a question just raise their hand, and then I will. Okay. I've got El Trobatla. Please go ahead, unmute, and ask your question.
Thank you, Mr. Letebele and Advocate Hussein, for the presentation. I actually wanted to find out regarding the reading list because I'm still having the 2022. I did my pupillage in 2022. So the reading list that I have is actually from that period. Has it been amended? And if yes, where can I get a hold of it? Thank you so much.
No, it has not been amended. We've been nagging the LPC to get us to amend it. That is why I mentioned that there may be cases that's not on that list. But if that happens in the exam, you'll be given a copy of the judgment. So don't worry about it. Okay.
Thank you so much, Advocate. And thank you, Mr. Letebele.
Thank you, ma'am. I've got, let me see the name here.
Achidisi.
KD.
Oh.
Just give me 1 sec. I just
Zomo.
have it as Kate. Please go ahead, sir.
Oh, good morning. I don't know maybe if it's a question or a concern because I wrote around September, but then some of the modules which are not legal drafting, we were required to draft maybe some document, and 1 hour is not enough. I mean, for drafting, we end up not finishing. I don't know if maybe I can be advised on that regard.
If I can tell you, the 4 papers outside of the drafting course does not require you to draft documents. And if you ran out of time, it's because you managed your time badly. We actually time these exams. We set the papers and we work out how much time you would need to answer it. So if you ran out of time, that's your fault. It's your problem. Okay, just take my advice as I gave it to you now, and you'll succeed. Yeah, next question.
We've got Makwarela Mochitsi. Please go ahead.
No, I think I'm the one who was talking.
Oh, okay. Yes, you are.
Okay.
You are. Next question.
Oh, okay. Okay. Sorry, before I take Amanda Nongogo, I had Kaya Jojo before that.
Yes, thank you.
Please go ahead.
Yes, thank you. Morning, Council. I've just got a question with regards to the active reading for the cases that would have been provided and the question papers and stuff like that. My question is, can we make notes or underline keywords and stuff on the actual question paper during the allocated question time before we can actually write on the actual script?
Absolutely. You can do that. Yeah.
Okay, the next question from Amanda Nongogo. Please go ahead, ma'am.
Amanda?
Good morning, Advocate, and thank you so much. My question is based on the reading list and what you had said about case law. For example, you look at motion court number 7, law of evidence. It will refers to reading certain books, and in those books, it will refers to case law. So there, although case law is not included in that reading list at number 7, we do need to focus on the case law that the book takes us to.
Yeah, listen, there's a trick to this. You don't have to read all the cases the book refers you to. Find the most recent decision of the highest court. That's all you need. One decision, no more than that. You don't have to read more. Okay. And how do you find that? If the textbooks refers you to a case, take that judgment, go and look up the annotations of that judgment. If that judgment was applied in an SCA judgment recently, that's all you have to read.
Thank you so much.
Okay.
Yeah, thank you, ma'am. I'd like to move on to Bontle Singo. Please go ahead, Bontle.
Bontle, unmute yourself. Okay, take the next question.
That was the last question, actually. I don't see any other hand. If you can give me a moment, let me just check on the Q&A. Advocate Hussein, and I'll just quickly run through the questions there. Okay. Okay. This question, I don't know if Yolisa is still on the call. Yolisa from the Education Department. There's a question that says, does the exam venue in Pretoria, Bridget Mabandla Justice College, have parking space?
I can't answer that question.
Okay, please do, sir.
No, I can't answer that question. I don't.
Okay. Oh, sorry, I misheard you there. I was asking my colleague from the Education Department, Yolisa, if I'm not sure if she's still on the call.
Mr. KB.
Yes, ma'am.
Yes, I'm still here. Yes, we do have a parking, but okay. I can't confirm for how many people.
Okay.
Yes, but we do have parking there.
Okay. Thank you, Yolisa.
Thank you.
And then let me. Are we allowed to bring snacks and refreshments into the exam? Into the exam for paper 5. I don't know why that specific paper, but snacks and refreshments, are they allowed?
Inside the exam room, no.
No, okay. No snacks allowed, okay. Let me see if there's any other question. Okay, if when you check your past exam script, you find that 2 questions were not marked or no marks at all were allotted to the questions, what recourse do you have as a pupil who wrote the last exam?
I'm not aware that there was a question that no mark was allocated. But you know what? You could work it out. Total up the marks that are allocated, see the difference between that and the total, and you got the marks. As long as you answered it, you won't suffer any prejudice at all. Just because there's no mark indicated doesn't mean you don't have to answer it.
Thanks, Advocate. I see I've got a hand from Rosemary Mashele. Rosemary, please unmute and ask your question.
Thank you so much. Good morning. I just want to check, Council, did I hear you well? Did you say that there's no drafting outside legal writing for the papers this year?
No, well, look, you're writing your answers, okay? You may be asked to draft a notice of motion or something like that. But it's not extensive drafting so that you can write pages and pages. That happens in the drafting exam. Just answer the question, you'll be okay.
Okay, thank you.
I'm just going to read two more comments, and then we will take Mantibile Mohale's question, and then I think we can then close the session. But the first comment here is, if I'm asked to write an opinion in a criminal procedure paper, am I going to be assessed on the structure as well?
You know, with opinions, advocates have a method of writing opinions, the 5-rack system, and you've all come across that. But in an exam, what we're looking for is your reasoned answer and recommendation. That's what we're looking for. If that comes out, the structure is not that important. It's your reasoning that was going to get you the marks. Okay.
Okay. So we will take a few more questions and then we'll wrap up, Advocate.
Fine,
Oh, noted.
Okay.
Can I take Mantibile Mohale, please?
Good morning, everyone. With regards to the exam, I just wanted to know, are we allowed to go with any specific textbook that will assist us? For example, Ambler's, Erasmus, or anyone of that nature? Thank you.
You are only allowed to take books into the open book exam. That's the drafting. Paper 5, not for any of the other 4 papers.
All right. Thank you very much.
Thank you, ma'am. I will now take Nikita Nkosi.
Thank you, sir. Can I ask if I'm audible first?
Yeah.
My question is not with regards to the exam. I would like to ask Sister Lisa regarding SACET and LPC funding that we are receiving as pupils.
Sorry, can you reserve that question for later? It's not for me. Are there any more questions for me?
Let me just take 2 more, sir, and then when we close your list, I can possibly respond on the SACETA question. I'm now going to take J.A. Motau. If you can please pose your question.
Thank you. Good morning, Advocate Hussein. I just wanted clarity on the question of legal drafting. Are we allowed to bring any book, or are there specific books that we are allowed to bring?
Yeah, there's a list somewhere. Just find out from the education department. There are books you can take into the drafting course. But I can tell you, taking lots of books into the course is not going to be of any assistance to you. Okay, that's a problem with open book exams. It's open book, so you're allowed to take books in, but a whole lot of books in, you're just going to get into trouble. Okay, yeah.
Thank you, Advocate. The final question I'd like to take is from Basela Yalezo. If you can please go ahead.
Thank you, sir. Mine is a quick one. Last year, we were told that we can bring Erasmus with markers, and then when we went to the exam, they said no, remove the markers, and then later on they said okay, you can put your markers back on. So what's the story this year? Should we come, or is it possible, or are we allowed to bring our books marked? What
for which exam?
For legal drafting.
Oh, yeah, you can bring it in. I mean, whether you've got you flagged it and so on doesn't matter. It really doesn't matter. Okay.
Advocate Hussein, I see one more comment or question in the chat. It says, is insolvency part of our exam for motion?
Go and check the syllabus. The syllabus will tell you. I can't remember now.
Okay.
The syllabus, then it's there.
Oh, okay. All good.
Yeah.
I do not have any other questions. I want to check with Yolisa regarding the SASITA question. Sis Yolisa, are you in a position to respond?
Mr. KB, I'm busy drafting an email for all the SASITA recipients. So can they just please wait for my email? I can't discuss that here.
Okay. Thank you so much. Thank you, Lisa. So the individuals who've applied for SASITA will get direct communication from the Education Department. Advocate Hussein, I just want to once more express our gratitude as the LPC for always, being willing, available, and giving guidance regarding these exam preparation sessions. It's much appreciated. I want to thank everyone who joined us this morning for this session. Please do remember that it will be available on our YouTube channel. And good luck with your exams. Keep going, and I'm certain that you'll do well. So all the best and good luck with the exams. For now, I'd like to end it here, and thank you so much. Have a wonderful rest of the day. Thank you, everybody.
Thank you. Goodbye.
Thank you.